Alex here with a high conflict child custody video on Discretion Revisited. This is one of the videos that I cite very frequently, not only in my docket series, but even in my other videos, even on interviews and such. And it is, I think, one of the most important, I think, I don't know if I want to use the word enablers of high conflict child custody, but maybe that's the best word to describe it. It at least does enable a lot of the bias and unfairness that occurs in the child custody system. So, in any event, the issue of discretion is a big issue. It's central to, I think, the problem of the family court system. And sometimes I get questions. One of the frustrating things about publishing these videos is they're monologues. You're just talking to the camera and therefore the audience. And you can't really engage in the sense of answering questions. And you can't really deal with being confronted on any points because people can't talk to you. And this is one of the videos that I've been wanting to do for a long time, and I've been gathering up a lot of the questions and confrontations people have brought to my attention. Questions usually come from the general public, confrontation usually from attorneys who are inside the system and like discretion. I think from the attorney perspective, it's hard to let go of one of the things that makes you look better. Discretion gives you the power to argue where you might not otherwise be able to argue, which, number one, validates the point of an attorney, which means more money. And number two, gives them an edge against non-attorneys, which is one of the things that I talk about in the original video, Discretion, that it rarely works in favor of the non-attorney. It usually works in favor of attorneys. In any event, let's deal with some of the questions that I get on, and maybe even the better way to go into this is examples, because the big concern, I guess, from the attorney side and question from the non-attorney side is, where do you draw the line? And you can't take it to the extreme. The issue of you can't take it to the extreme, I think, is obvious. That's just one of the things that goes hand in hand with speaking in generalities. A lot of times people will say, well, that doesn't always apply when it comes to one of my videos. Well, of course not. I'm speaking in generalities. There's exceptions sometimes, and then there's exceptions to the exceptions sometimes. And when it comes to extreme, I mean, that makes sense. I mean, you can't really take the idea, or many ideas can't really be taken to an extreme. So I'm going to take this opportunity now in this video to come up with some examples of what I mean when I talk about closing discretionary windows, or at least narrowing them, making them smaller. And of course, my whole idea is there is going to be some discretion in the court system that's just impossible to totally get rid of. But just because there needs to be some doesn't mean that you should take an issue and completely open it up to whatever the court feels like doing. So anyway, obvious examples, for example, we'll have the right of first refusal. That's something that's just left to the discretion of the court. And what happens is many judges will order right of first refusal just because they don't know any better, only to find out later on, when a million different contempt motions start getting filed in their court, that it's not a good idea. That's something that could be codified in a statute. The legislature could say something like, if there is conflict in a child custody case, the court cannot order right of first refusal. Sorry, but it just doesn't work. It makes the case which has conflict have more conflict. And that's one of the things that policymakers are supposed to decide for the judges. They're supposed to consider, all the arguments, have a debate, and then make a decision, enact a statute. And now the judges don't have to do that because the legislature's already done it for them. And the legislature's given them an instruction. And that instruction is, do not order right of first refusal. Why would that help? Hey, if you're in a high conflict case and your judge orders right of first refusal and a statute said they're not allowed to, now you can fix the problem. In Nevada, if a judge decided it's in the best interest of the child to do this, there's probably nothing you could do as a parent except file a bunch of contempt motions until the judge goes bananas and changes their mind. Sorry to say, if this legislature doesn't say so, oftentimes the standard you're left with is abuse of discretion, which is not a very reliable standard. You usually won't be able to really know what's going to happen with your appeal. When there's plain statutory language, you can predict more accurately, okay, this is going to overturn. Let's take a shot and file an appeal. But when you're dealing with abuse of discretion, it's not that clear. So yes, a statute like that would help a lot. Another example might be child support deviations. Child support is a hugely contentious issue in child custody cases. I don't think you can get rid of it because of the welfare problem. I talk about that in the video. Um, there's a video, I wish I could remember it. It's based on one of those federal acts that a lot of people are opposed to. It's a federal act that gives the state money for going up against parents and collecting child support money. They get some kind of like commission for it. And so it is going to post in the comments below. I can't believe it's escaped my mind right now. But in any event, same thing. I mean, I don't think you can get rid of child support because of the welfare problem, but I sure do think you can make it a whole lot more fair. And that is one of the areas that I remember in Nevada being one of the most predictable areas because it was formulaic. You know, you'd put in the dollar amounts and out would come a number. Then they had deviations, and that makes things a little dicey. The Supreme Court and the legislature has dealt with that by saying, you know, specific findings have to be made, but maybe they can do more to limit that kind of stuff. For example, maybe they can say no more deviations for using daycare. That's what child support's for. If they have to, I mean, in my opinion, if they had to raise child support a few percentages to get rid of the deviation for something like daycare, child care, I would say go for it. Anytime you have an issue that is hotly contested, like child support, you want to really narrow down those discretionary windows because that's where people feel the unfairness comes in. You have one judge who's like, yeah, you need to pay $500 in daycare a month. You have another judge who's like, nah, I think you're doing good with the child support you have. And then people notice the imbalances and the differences, especially when one side has an attorney and one side doesn't. I don't think that attorneys like the idea because, as I mentioned earlier in the video, that means it's one less thing they can argue about. More discretion means more for them to argue. Less discretion means more predictability for us and, quite frankly, an easier time, I think, for the non-attorney, for the person who's representing themselves, because that's the person who's a nobody, who can't compete with those lawyers who lunch with each other, but they can say, hey, this statute says you can't do this. And if they do it, they can file an appeal. It's really frustrating that that's the attitude somebody has to have when they go into the system, but that's what actually works. At least that's my experience in my case. And if people here who are watching this video haven't seen it, you can watch on my docket series and go through my entire case, every single filing and every single hearing. So those are just a couple of examples. I think another thing that would be really a great idea to codify would be if there's high conflict cases, the court's not allowed to force people to go to the same appointments. I would have loved that statute. I mean, I've covered this in a few videos, and people who didn't have, I think, a high conflict ex didn't understand why I would agree to that. And I think what I said was, it was something like this. On paper, you can have the right to do something, but your ex can go so crazy at these appointments that it doesn't even matter what you have on paper. You're just not going to go just because, number one, it's embarrassing for the family since you've split up, and number two, it's what's the point? What's the point of having this right if in reality they're just going to violate it anyway? It's better to separate these things out so that at least you not only have half the rights that you originally had on paper, but at least you could actually exercise the half the rights that you now have in reality because your ex can't go. So I think that would be great for the court to say, hey, if this is a high conflict child, or for the legislature to say, hey, if there's a high conflict case, you are not allowed to order parents to go to the same appointments. Make them take turns or divide. I think I talk about this in the video, modifying legal custody. Divide up the legal custody rights and obligations. Divide these things up, split them up so that parents now can at least in a high conflict custody case have their sanity when they go to these things that they should be a part of, because the other parent is ruthless and they don't care. If they can go to an event with you, they don't mind that at all. They'll go. They'll cause all kinds of scenes. They'll pull all kinds of stunts. They don't care. They know you do care, but they don't care. So that's another thing, is if the legislature codified that statutory language, if they said high conflict cases, make them take turns when they go to appointments, things like that. Now a judge is forced to do what they probably should be doing from the beginning. And I hate to say it like that, like they don't know what's going on. And it's not in the sense that I'm trying to disparage the judiciary. I just think that the issue is so counterintuitive that if you don't really think it through and if you don't have experience, it's very easy to see how the judge makes the wrong decision. It's a very counterintuitive issue to take two parents and say, no, you can't go to these things at the same time. People who don't understand high conflict child custody, they don't get that. They'll be like, why? Why can't you guys go to the same soccer game? What's wrong? You guys are unreasonable. That's what regular people think. People who've gone through an actual high conflict custody case know that it's an insane situation that is anything but ordinary, that you're dealing with an irrational person. So yeah, that would be another great thing. Same, I kind of dovetail a little bit into extracurriculars there with the soccer game thing, but that has to be codified for sure. Who pays for extracurriculars and who gets to go and when? In a high conflict case, that's a massive point of contention, and it can become a huge source of conflict if the court doesn't know what it's doing. That's another area that should be codified. These probably the biggest rule of thumb when it comes to what should the legislature do to limit discretion in these cases is tackle the counterintuitive issues that come up in child custody cases, because there are many. There are many, and the judges need instructions in these areas. It is not something, and I guess this may be where the idea of let's give them a ton of discretion came from. It's not something that somebody with common sense can just do. You can't just go in there and think, I know, I'm a reasonable judge, I have common sense, I'm going to be able to handle all the. No, you're not. The high conflict child custody cases are insane cases where people do deliberately do things that will create conflict and harm their children. And so to deal with these counterintuitive issues, they need instructions. They need statutory language to force certain things to occur and to forbid other things from occurring. I talked in the beginning about the use of right of first refusal. I mean, even if the legislature didn't want to get rid of it completely, they could at least say something like a judge is not allowed to order right of first refusal when a parent is unavailable for 4 hours or 8 hours, because that's going to create right of first refusal every time somebody goes to work. And the other person might decide, I'm never going to go to work. And I know a lot of people would say that sounds crazy. Who is going to do that? No. High conflict parents are crazy. They will do that. A parent will think to themselves, all I have to do is just never go to work. I'll just be a bum at home, and then I'll just get the child every single day that the other person does go to work. And now there's right of first refusal every single day, which creates an additional 10 exchanges per week. And as I've explained in my previous videos, I think specifically timeshare exchanges. Exchanges are one of the easiest areas for a high conflict ex to cause issues, for them to make your life a living nightmare. So the legislature needs to figure this out and enact a statute that says no more right of first refusal. Or maybe they could say something like, if a parent is gone for a full day, maybe if a parent goes on a vacation and they're going to leave their kid with a sitter for like a week, or like I see, even a day, that's much more reasonable. But the judges need instructions, because some judges don't get that. They don't know that that's a problem. And so they just allow it to happen because they're just ignorant. And like I said, guys, very counterintuitive. If you talk to somebody about, hey, isn't it a good idea for when one parent is unavailable, the other parent has a right to watch them, before they go to a sitter? Probably 99% of people who've never gone through one of these cases is going to say, yeah, that's obvious. Yeah, that's common sense. Of course. Why would you put a child with a sitter when the other parent's available to watch them? Of course they should watch. Most people think that that's an obvious thing to do. Most people think that that's common sense. People who've gone through high conflict child custody know better. So these are areas that are very counterintuitive, where the judge needs to be told what to do. And it's not like this is the only area of law where this occurs. Judges are told what to do all the time in criminal law, in civil law. It's just child custody law where somebody decided, let's just let them do whatever they want. Anyway, I'm going to try to think of a few other good examples, because right of first refusal is one of the more obvious ones, as is child support, which I said you probably can't get rid of it because of the welfare problem, but you probably should make that as little discretion as you possibly can. Make it as predictable as possible when it comes to child support, so that people, when going through that really hotly contested emotional area, are less exposed to prejudices and biases than they ordinarily would be. And I do believe that in some states, they probably are given way too much latitude on child support, on an issue that, and it's funny because a lot of attorneys and judges even concede that that's a point where there's a lot of emotional anguish, yet they don't do anything to make it as as emotionless as possible to streamline it and to make it so that it's one of those things where this is how it's going to be and nobody can do anything about it. Even that hotshot lawyer, you can pay that hotshot lawyer $1,000,000, but the statute is a statute, it's a formula, and it doesn't matter how much you pay that lawyer. This is going to be what it is until they, other things like with child support, like if you modify, then you always modify back to the date that the motion was filed. Something like this could be huge towards eliminating unnecessary litigation. When the legislature does not do things like this, attorneys are like, okay, well, yeah, your ex has a right to modify child support downward. That's true, but they're probably not going to get a hearing for 3 months. So let's just come up with a bogus opposition, drag our feet for 3 months, and then at the very end, when you lose and your child support is modified downwards anyway, like we knew it was going to be, at least you got to pocket all that money for those 3 months. Like now, you are wasting the court's time with a hearing that wasn't necessary, and you're wasting the litigants' money because now attorneys are getting paid for something that they wouldn't even have to do. If there was a statute that said it is mandatory to modify child support back to the date of the motion being filed, now there's no more incentive to drag your feet. Now there's no reason for the attorney to say, well, it's true, the law's not on your side, let's drag it out for 3 months, because then at the end of the road, the judge is just going to retroactively modify back those 3 months anyway. Things like that, unnecessary discretionary windows, they're just not needed. That can be closed down, that can be shut off. I'm going to try to think of a few more before I sign off. I covered the issue of taking turns at appointments. I covered extracurriculars, things like makeup time. I don't understand why that's discretionary. If a parent was deprived of visitation, they should get their visitation. That should be mandatory. They should even consider doing a 2-for-1 penalty because everybody's time is getting wasted. There's been some people who are like, well, what if the other parent lost like 2 months of time? I don't think it would be fair to give that other parent now 2 months of makeup time. Why? The thing that you're concerned of, which is a child not seeing one of their parents for 2 months, has actually already occurred because the parent who violated the order hasn't seen their child for 2 months. So it's stuff like that actually gets used by judges too. So that's an area where a statute could say that they have to do it, and that would be one area less where people would think it's not fair. People do think it's unfair when their child is withheld from them for 2 months and then they go into court and the judge is like, shame on you, slap on the wrist. But yeah, I can't give you 2 months of your child now because, then the child wouldn't see the other parent and that's too long of a time. And it's like, hello, this just happened to me. Do you not care that it's in favor of the court order violator and not the victim? Guardians ad litem, and custody evaluators. I really understand that it makes, I don't even know if I want to say this, makes the job of the judge easier, because maybe easier isn't the right word. Maybe it makes it so they don't even have to do their job. I didn't have any experience in my case with child custody evaluators and guardians ad litem, but really, it's one of those areas where money is horribly crippling to parents. And I really would like to see something from the legislature where they say something like, you cannot order families to get one of these providers unless they're making at least $100,000 a year or something like that. Because, the costs are so high and the parents are already paying their attorneys. Some of them can't even afford an attorney, so they have to go into court. So it would be nice to see some kind of statute that required the court to make a finding that the family was making at least $100,000 combined before they force them to pay for guardians ad litem and other custody evaluators and such. Same thing for parenting coordinators, so that's easier to deal with since you can just veto it. If you want to know why, watch my video on the topic, parenting coordinators. The last thing is attorney fees and costs. I think that attorney fees especially is, in my opinion, very close to how I think they should deal, or very close to how I said they should probably deal with child support. It's an area that it should probably be as little discretion as possible. I very strongly believe that attorneys and family court judges abuse attorney fee discretion very, very strongly. And I believe that the solution to that problem should be strict statutory language limiting when child custody awards can be given out in these cases. I really wish the legislature and the government knew just how angry child support, or sorry, attorney fee awards in child custody cases make the parent. It creates. It's one of the things that I think creates the greatest sort of vitriol, not even just against the family court system and the government, but it actually adds to the hatred and the vitriol between the parents as well. And it's one of those things that I think is also counterintuitive. I really have to say that. I can understand why attorneys and legislatures would say, though I don't know if they really believe what they're saying. Some of them, I think they're just saying it because they want it to be, a law, and they don't want to really um, say what the truth is with regards to attorney fees. But in any event, a lot of people think, well, it's not fair that you had to pay your attorney, and so, or because presumably because you won, and so yeah, the other person should have to pay, and they don't understand that there are so few people that are able to afford an attorney in child custody cases. I think it's somewhere around half, and so this situation is extremely unfair when one side doesn't have an attorney and the other one does. And the reason is because the side that has an attorney can do all sorts of abusive litigation practices, file all sorts of crazy motions, or even just dig their heels in and oppose things that they shouldn't. And they don't have to worry because the other side doesn't have an attorney. They're too poor. And then you have the situation where the person who's self-represented, who has no formal legal training, they're the ones that have to constantly worry about being forced to pay attorney fees that they already can't afford to pay. They don't have an attorney. And this idea that, well, you can just make them split the attorney fees, make the richer person pay for the poor person's attorney fees. And all you're doing is taking a situation that is already bad and making it worse. I talk about that in the video attorney fee equalizers, so I'm not going to go into it anymore. Please watch my video on the topic attorney fee equalizers to learn more. What I am going to say is that this is an area that should have very little discretion. I do believe that there is a statute in Nevada that allows the court to award attorney fees if somebody files something to harass or without a reasonable basis, and that's probably the best way to go with it. I think that's should be the beginning and the end of how attorney fees work in child custody cases. There's also a contempt of court statute that says if you prevail on contempt of court, you're entitled to fees. That makes sense too. There's a court order, somebody violated it. Okay, fees, that makes sense. But there's these other areas of law, and I don't think it's just generally in Nevada. I think there's also some stuff in the paternity code where a judge can just decide to award fees because they feel like it. And then there's something in there, or there was a debate in the legislature on that statute in particular, where they said that they were upset that a rich person could get a lawyer and a poor person couldn't get a lawyer. But if you look at the actual language that they pushed through, it doesn't mention anything about that at all. It's just a statute that says that the family court judge can award fees anytime there's a custody issue. There's nothing in there about rich, poor, more money, less money, nothing. So they sometimes have these debates in the legislature, and then they pass a statute with a colossal discretionary window where a judge can do whatever they want. Stuff like that shouldn't exist for attorney fees. Costs, I think, this might make people wonder why I have this opinion, but I think costs should be mandatory just to whoever wins. Number one, costs are usually not that expensive. Maybe if somebody has to pay for like a transcript or something like that, it might be like $100, unless it's a really long hearing. But usually it's like postage stamps, mailing, a filing fee here or there. I think that would be the perfect balance when it came to these high conflict child custody cases, that the prevailing party gets an awarded costs, but getting attorney fees is a lot harder. In any event, there's a whole bunch of other ideas that I'm sure people would come up with when it comes to limiting discretion. There are so many different areas in high conflict child custody cases where there is discretion that you can't get rid of, but you sure can at least cut down on it. And I think that would be a good first step. The last thing I want to mention is at least I wanted to mention an area where it makes sense that there's discretion, so that this whole video isn't just me bashing on it. But a very obvious area is the best interest factors. You have like 10, 11, 12 best interest factors. You really can't say how you're going to weigh one more than the other, because these different factors may apply in different ways to different families. So that's an area, I just wanted to give an example of an area where it makes sense that there's discretion. Yeah, the court has to consider 11 factors, but there really isn't any specific hard and fast rule that the legislature can come up with to tell them you need to weigh this factor more, you need to weigh this factor less, stuff like that. I hope that this video makes sense to people. I hope it shows people that I actually have thought this through, that I'm not just like, discretion's evil, and that's the beginning and end of my thought process. I've thought it through, but as I mentioned in my video, policy versus the law, I really don't like to go into the topic of these are the laws we should have, because that's not the point of this channel. But I at least want to let people know discretion there's more to discretion than just the original video discretion, and give people some really good examples and ideas. And if I was going to, at the end of the day, highlight or underline a specific concept from this video, that concept would be that in high conflict child custody cases, there are a lot of counterintuitive things, problems, approaches, solutions, whatever. And with any sort of counterintuitive issue, at first glance, you're going to be deceived as to how to approach it. That's just, the nature of counterintuitiveness. You're going to look at something, you're going to see an obvious solution, and that's wrong. That's the wrong approach. And I wanted people to know that that's where the legislature should step in and enact some plain statutory language to control some of the stuff that's going on in the child custody cases, and maybe not see it so much as being mean to the family court judge and taking away their power. Maybe seeing it more as doing to the family court judge what they already do to all the other judges anyway. And it's more guidance than it is control. In a sense, it's basically saying, we have debated this is the solution that needs to be taken, take this solution. You're telling them what to do, but at the same time, you're kind of guiding them. Again, guys, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.